Thank you for joining us today. For those of you who don't know me, I'll make a quick introduction. I am Hannah Shea with World Law Group, and I work with our 15 practice and industry groups. This meeting today is hosted by the Restructuring and Insolvency Resolution Group. So thank you for joining us. I will ask before we get started, if you could hover over your video and click the three dots at the upper right-hand corner and select rename and include your firm name. Jonathan has done so. Julia and Alexandra, Sonia, thank you. If you have a challenge doing that, please feel free to send me a chat and I am happy to help you do that. We do encourage you to participate in the discussion today. Jonathan may even call on you. So if you can turn your video on, great, but we totally understand if that's not possible. Lastly, I will say that we do record our meetings and post them on the website after. You will see that there's a transcript at the top that helps us with our note taking. It's called Otter AI that records the transcript and then sends me a nice summary of the meeting, which of course, with all things AI, I do have to monitor and make edits too. But I did just want to let you know that we do that. And with that, I'm going to hand it over to Jonathan to kick off the discussion.
Hello, everyone. Nice to see you all, and thanks for joining the meeting. And on behalf of my co-chairs of this group, Alexandra Schluck-Amend, Ann Smith-Manon, and Chris Armstrong from Goodman's, who was unable to join today, we're really glad to be together. We were going to share a few trends that we're seeing in our respective jurisdictions, and then we were going to check in with each of you and invite you to do the same. And as is always the case in these meetings, you don't need to speak if we call on you, but you're welcome to speak. And one of the things we really like about this particular group is there's a lot of interesting similarities and common points of reference for those of us practicing in this space across multiple jurisdictions. So it's always quite interesting for me to hear what's going on in your jurisdictions and to see how the themes we all deal with vary a bit from place to place. Before we start, Sandhya, do you have a colleague joining you today?
Yes, my colleague is Supriya. She's a senior teammate who handles insolvency and restructuring matters.
Thank you, Supriya. So nice to have you join us. I don't mean to put you on the spot, but do you want to say a word or two about your interests and background and what you do?
Yes, so I have 8 years of experience in the field of litigation, and insolvency regime changed post 2016. The laws were restructured in that sense in India. So my experience in insolvency since 2016 has been really thorough that way. And I'm glad to be a part of this discussion today.
Well, thank you so much for joining. I hope you'll come back, and really good to have you. And we've had prior programming with some of your colleagues at Vaish, so we're very aware of your excellent insolvency statute, and it seems like there's been a lot of good activity based on that statute. So really glad to have you both here. Did anybody else bring a colleague?
Yes. I have also a colleague with me, Julia Menke from Cologne.
Hello, everybody.
Julia, so nice to see you. Would you like to just say a few quick words about your practice and what you do?
Yes, I'm also in the insolvency and restructuring branch, and I've joined CMS 2.5 years ago, and this was also my start being a lawyer. So I'm not as experienced as our colleagues from India, but I'm also very happy to get all of the international cooperation and getting to know all the trends happening in other jurisdictions. We experience many trends in the real estate topic right now. And yeah, I'm very happy that Mrs. Schluck-Arndt took me here today.
Wonderful. Just for my own benefit, is that Cologne in the background on your screen?
Yeah, actually in the Rhine.
Quite
That's
nice.
the dome, and here's our office.
Quite nice. Very nice. Well, thank you. Great. Did anybody else bring a colleague? And by the way, no deadline on that. We're going to be trying to invite others to these meetings and expand our circle. Smith, were you about to say something?
Yes, I have my colleague Joel Chung on the call. He's actually dialing in from China. Joel does all insolvency and particularly with the China focus. So he's on the call as well.
Wonderful. I see Joel. Joel,
Yeah.
thanks so much for joining. Would you like to say a few words about your practice?
Yes. Hi, everybody. My name is Joel. So I work a lot with Spencer with the Loan Partnership Restructuring Insolvency team. My focus, I think, is I would say maybe split between litigation, arbitration, and also insolvency and restructuring. And in recent years, it's a particular focus on the Greater China region. We have a representative office in Shanghai, and I am supposed to be, splitting my time between Shanghai and Singapore. Yeah. So I'm also trying to look at more restructuring insolvency projects with a more regional focus, maybe connecting, Singapore with Shanghai and also perhaps Indonesia as well.
Wonderful. I'm going to ask you a question, and I'm going to go back and also ask it to Julia and Supriya. Are there industries in particular you focus on or of interest, or are you a generalist across industries?
Probably more of a generalist. I think given the size of the Singapore insolvency market, we tend to be a bit of a specialist depending on the flavor of the month or the flavor of the year.
Excellent. Julia, I'm going to guess you do automotive, but maybe I shouldn't. What? Oh, you're muted. You're muted. Sorry.
Because we're Germany based, no, I would agree to all that Joel has stated for his job as well. We are not specialized in any branch and a generalist as well.
Jonathan, Julia is in Cologne and not in Stuttgart.
Okay. All
In
right.
Stuttgart, the colleagues would always say they are specialized in automotive and in energy, but not outside of Stuttgart.
All right. I made a bad assumption. Forgive me. I'm a generalist too, so I completely sympathize. Supriya, how about you?
Even we have a general practice, though we have more of matters coming from the banking finance side, but generally we are open to practicing in all sectors.
Okay, wonderful. Any other colleagues to introduce?
Yes, on our side at Arendt, we also have Valentina de Femia who is joining us today, and she's a senior with us. We are not together because I'm not in Luxembourg today, but Valentina is.
Hello, everyone.
Wonderful.
Pleased to meet you all.
Thank you so much. Well, Matthew, thank you for inviting her, and Valentina, welcome. Would you like to say a few words about your practice and what you do?
Yes, so I'm part of the restructuring and insolvency team at Arendt. I have a focus on corporate law, so I'm in the team of the corporate law restructuring and insolvency here, and I've been practicing for 7.5 years, more or less. Yes, and
Sure.
we've been having some very interesting files on the restructuring side of things, so we've been pretty busy in the past years.
Terrific. What kinds of industries?
I think the industry is very much varied. So like everyone else here, we don't have a specific focus. So very broad perspective there.
Terrific. Well, so glad to have you join us. Thank you. I see somebody on the phone with a 352 prefix.
That's me dialing in.
Yeah.
Yes.
Okay. All right. I thought someone else wanted to speak. Terrific. So thank you for all of that. Did we get everybody? Any other new colleagues joining we should say hello to?
We have also Valentina and Petra.
Sorry, say again.
We have also Valentina and Fedra in the call.
Okay.
Valentina, would you like to introduce yourself?
Yes.
Or Fedra, start.
Yes, me. I mean, you can see probably the other line moving. It's the number because I'm in dial-in, but I've it's me, Valentina. So I just introduced
okay,
myself right
sorry.
now.
Yeah.
I know I'm
Yeah.
double there.
That was my confusion too, but
Sorry for the
Okay,
confusion.
sorry.
I think we have.
I'm speaking from another box.
Well, you know, it just looks, when the box lights up, it looks like someone wants to speak. So that's why we both thought it was someone else.
We are trying to double the numbers, so that's why. So
we thank you for it. We love goosing our numbers. It's good. I have a terrific colleague who will be joining the next one, but could not make it for this one, Chelsea List. So I'll look forward to introducing you all to her on the next call. And really welcome to all of you. Please keep coming back to these meetings. You know, we think for our group and for the World Law Group in general, you know, this is really a multi-generational organization, and we're really interested in bringing next generation lawyers into this practice group and hearing about your experiences and your ideas. So thank you, and please keep coming back. Alexandra, Smitha, any other preliminary thoughts on your end before we get into trends? Shall we start with trends then? Alexandra, do you want to take a shot at your slides, or?
Yes, I can share some slides if Hannah helps me. Hannah, can you share the slides, please?
Hannah, you're muted, Hannah.
Yes, I am working on getting these shared. Give me one moment. Okay. And let me know if you see in the slide mode. Do we see them?
Yep, they're visible for me.
We can see them.
Do you see just the first slide?
Yes.
Okay, perfect.
Yeah, then let's start. I'm happy to share with you some views on the legislation trends and not the market trends, because I think we can discuss about the market trends. And we had a pre-discussion between the leaders, and I thought the most trends are really worldwide. So that I would like to show you that we have in Europe a trend with regard to the law. And therefore you can see the agenda, the next slide. I would like to show you first Insolvency 3. This is a legal framework on the European level. And then I would like to say something about ESG, because also on ESG things, we have lots of European jurisdictions and laws, which we have to implement in the national laws. In the meantime, our daily work is really shaped to a considerable extent by standards, in the background of which is the implementation of a European legal act. One prominent example from the recent past in restructuring is the Act on the Stabilization and Restructuring Framework for Enterprises, in Germany, STARUG, which stems from the EU Restructuring Directive of 2019 and obliges all member states to create a pre-insolvency restructuring framework. That means that we also can do restructuring without the consent of all parties in a situation in which we are not in official insolvency proceedings. Today, I would like to introduce you to the next changes in the European insolvency law that are already on the horizon. In December last year, a new draft directive was published by the Commission, which goes under the heading Insolvency 3, or draft directive on the harmonization of certain aspects of insolvency law. And this brings new upheavals for the different European insolvency laws. I would like to give you also a short insight on a topic that is becoming increasingly important, particularly in Europe, I think, but also worldwide. Yeah, specifically, it is about the question of the impact of ESG on restructuring. Yeah, that's the agenda. And then first, we look on the core aspects of the Insolvency III Directive. And also, I would like to give you a briefly outline to the status quo of the, especially German insolvency. The next slide, please, is with the core aspects. Yeah, insolvency rules are regulated differently at a national level of the member states. We do not have so much material law on the European law level with regard to insolvency. There are lots of differences, and the differences are especially in the efficiency of the various insolvency laws. The lack of harmonization has long been identified as one of the main obstacles to the free movement of the capital in the EU and to greater integration of the EU capital markets. And this is to be remedied by the Insolvency III Directive. So in summary, there are 6 main aspects of the directive that can be identified. First is the duty to file for insolvency. At the moment, we do not have in each European country a duty to file for insolvency. And this should be implemented by the directive so that the directors of a company are urged to file for insolvency and to start insolvency proceedings no later than 3 months after they become aware of the insolvency or could reasonably have expected it. The second main aspect is the harmonization of contestation law. We also do not have in each European country a contestation law, but this should be implemented in each European country. Then we have rules on creditor committees, so that in insolvency proceedings, there must be established a creditors committee, and the creditors committees should be to review whether the insolvency proceedings being conducted in a manner that protects the interests of the creditors. The fourth aspect is a procedure to simplified liquidation. The draft directive provides for simplified liquidation procedure for micro enterprises. And according to the directive, micro enterprises are enterprises which employ fewer than 10 persons and whose annual turnover or annual balance sheet total does not exceed 2 million euro. One of the special features of simplified liquidation procedures is that an insolvency administrator is generally not appointed. The individual steps are generally carried out by the debtor in self-administration. And the fifth point is a pre-pack procedure. Yeah, there's planned that this is very discussed in legal academic literature, because this is very new that a pre-pack proceeding within the meaning of the Insolvency III Directive is characterized by the fact that an insolvent debtor can prepare the sale of his company to an investor in a preparatory phase prior to insolvency proceedings. That means that the business will be sold to an investor, and then the company, the entity, will be in insolvency proceedings and will be liquidated in insolvency proceedings. Yeah, and to support this, national law must provide for the possibility of a moratorium during the preparatory phase. And depending on the decision of the member state itself, the sale of the company must then either be confirmed by a court in a liquidation procedure which must be completed quickly, or the company must be put up for the public auction. Yeah, the pre-pack process does compromise 2 phases, namely preparation phase and then the liquidation. Yeah, and the last aspect of the directive is asset tracing. And asset tracing is very important for especially insolvency administrators in the future, because the insolvency law is a national law, and also the possibilities to act are only in the country of the insolvency proceedings, and the powers of the insolvency administrators have, under the laws of the member state in which the main insolvency proceedings were opened and in which they were appointed when tracing assets of the insolvency estate, should now also be available in another member state. One example to name is the cross-border access to asset registers. Ultimately, this will benefit the community of creditors whose interest in obtaining the full possibility satisfaction will be taken into account and strengthened. So asset tracing is, everybody agrees on that, and it's really important to safeguard the creditors. When we now look on the status in Germany on the next slide, we do not have so much to implement because we have already a creditors committee, and we have also already contestation law, and also the duty to file for insolvency. So we have especially need for implementation with regard to the simplified liquidation procedure, with regard to the asset tracing, and with regard to the pre-pack procedure. And therefore, we have at the moment lots of discussions on these 3 points. And most of discussions are with regard to the simplified liquidation procedure. And at the moment, we are not really sure if this will come, because the insolvency administrators, they have a very big lobby in Germany, and they see big problems in this simplified liquidation procedure without insolvency administrators. We also look to other countries if there such systems are functionable, and if you know about such simplified liquidation procedures and I have positive, think this is a positive thing, then let me know, because at the moment we think that this will not come. But asset tracing will come because everybody agrees that this is very important, and also something with regard to the pre-pack procedure, because we see cases in which an M&A deal cannot be finalized before insolvency, and then in insolvency proceedings you start from bottom. And therefore this would be a good thing to really survive companies and businesses without insolvency proceedings in the business, so that a business can be continued without any stop with regard to the insolvency. This is the overview about the legislation in Europe with regard to insolvency law, and then perhaps some words about ESG. But I think also, I'm not sure if anybody else will also speak about ESG, so we could also make this afterwards. Then I would say or what do you think?
Well, let's just take a moment first of all, and should we take the slides down for just a moment, Hannah? And I don't know, Matthew, did you want to comment on any of these developments? Anything in your jurisdiction, either for you or for Valentina, that comes to mind on these points?
Yeah, I think that in respect of these procedures, we've got quite some news in Luxembourg, because we've got a new law since a few months, and we are moving from a pure, let's say, insolvency bankruptcy approach with not much of a restructuring approach into the law to something which is a lot more modern, and which would have been there since years actually, but that we are very happy to have now, with also so the possibility to have some reorganization being done, it being judicial reorganization or out of court reorganization, which are also organized by our law now. While until now, and now being actually until the end of this month, because this new law will enter into play 1st of November, until now, starting any proceeding in Luxembourg would have meant going to bankruptcy. So you would always try to avoid starting a procedure in order to avoid being bankrupt, except if indeed you wanted to liquidate the company. And we will have now new tools, a lot more modern, and which are in this frame that was mentioned right now, in order to have reorganization. Happy to extend a bit on that, or Valentina to say a few words on that as well. But yeah, that is our trend in this respect, and so very new, and we are very happy to have that.
I'm going to invite Valentina and Fedra if she likes to weigh in on this, but quick question to you, Alexandra. You know, I'm always just so thunderstruck by the prohibitions on trading while insolvent. You know, this whole notion that a director has personal liability for continuing to operate the company while in a position of insolvency. And that always floors me, because that's all US directors do, is operate while insolvent. It's like most of what I see in my practice. So how do the, well, I'm sorry, I should also add, I know that during COVID, the prohibitions on trading while insolvent were relaxed somewhat as well. I guess my question is, in this new Insolvency 3 regime, and with some of these reorganization options, how are they going to harmonize the general rules against trading while insolvent?
There's not anything written with regard to the liability risks if they do not file for insolvency. It's only written the obligation to file for insolvency, because we have really completely different systems with regard to the liability. And this is again written in national law. And in Germany, for example, we have also a criminal liability when a director is not going to the court in time.
So would it avoid the personal liability simply to initiate the judicial proceeding? Is that the answer?
Yes, there will be liability in each country, and already there is a liability, even if there's no duty to file. Yeah, according to the UK law, you don't have a duty to file, but when you don't file, you are liable for everything vis-a-vis the creditors, and therefore they go to the court and file.
But what happens during the 2 to 3 months you might be trying? I know it's a new statute, but what happens during the 2 or 3 months you're trying to negotiate a prepackaged restructuring?
As long as you would think that it is more probable than not that you come to a solution, you don't have an insolvency ground, and therefore you are not obliged to file for insolvency.
Okay, interesting.
This is the system, yeah.
Interesting. Valentina, did you want to offer any thoughts on that?
Yes, sure. So, I mean, currently in terms of obligation and duties of the directors in Luxembourg, there is an obligation to file for bankruptcy if certain criteria are met. What's interesting with the new reform that is aimed at modernizing the insolvency law in Luxembourg is that you will have the stay within which, for instance, for judicial reorganization proceedings, you can have that time to reach an agreement with the creditors. So the aim there is really to also involve the creditors in the discussions. So that's an interesting new addition to the Luxembourg toolbox of insolvency.
Thank you. Fedra, did you want to weigh in at all from the Spanish perspective?
Maybe
Yes.
sorry to interrupt. One thing that I wanted to add to what Valentina just said is in respect of this stay, because stay is very important indeed. But we've got also something very strong in Luxembourg, which is the possibility to enforce security anytime. And the stay that Valentina mentioned will have no effect on that. So it will be a stay except on collateral arrangement, which will remain and which will also remain enforceable. And we can discuss at a later stage, but yes, indeed, possibility to enforce at any time in Luxembourg is something very strong, and which is also quite attractive for some of this restructuring business. So sorry, I interrupted.
Thank you very much. Fedra, love to hear the Spanish perspective.
Hi everyone. Two things on directors' liability. I don't know in the rest of the European countries, but here in Spain there was a big discussion on whether Article 19 of the current directive, of the directive of 2019, makes a shift of directors' duty from the company towards the creditors. That discussion here in Spain, the parliament decided that it has changed nothing in our system, and now with this discussion of the new directive that Alexandra was explaining, apparently what the Commission is deciding is that the only duty that can be harmonized on a European level is the duty to file, as Alexandra was explaining. We have already that in Spain, so I don't know what would be the development, but I don't think that we have to change a lot. And we already have our micro enterprise proceedings that is not working. Because it's the whole proceeding is through a web page. The web page doesn't work, so you cannot file electronically. You must go make that electronically, then go with the paper to the courts. But we are in the experiment. It's true that the micro enterprises size has been downsized here in Spain, but we are having that experiment, and we already also have a pre-package that was developed by the courts and by the judge. They decided that the whole liquidation proceeding, formal proceeding in the insolvency doesn't work. So there's been a lot of judgment and resolutions making this proceeding easier for the companies. It's true that we will need to adapt it to the new directive, but we have those two figures nowadays in Spain.
Wonderful. Thank you for sharing that. Julia, anything you want to add? You're muted, sorry.
Yeah, I was searching the button. I think that the points Mrs. Schluck-Ahmed has raised are kind of exhaustive to the thoughts that I have gained during my working experience. So I don't need to add something.
Okay.
According to
but Julia, you can say something about a shift of duty, and that in Germany we also discuss about that.
Yeah, we have also discussed about the shift of duties, but in Germany, most of the opinions are against the shift of duties, and I think the focus to have on the benefits of the creditors is like the system right now. I think in Germany works pretty well. So I was kind of shocked hearing about the things going on in Spain, also regarding restructuring tools in the insolvency code already, and the implementation of the directive. In Germany, we are also kind of relaxed regarding the changes which will come, and the assets to be registered is something everybody is really happy about, because it's the asset tracing in Germany is really complicated. To search for property and real estates, you have to write to the local courts when you want to when the administrator tries to trace the assets. So that's a real big benefit for Germany.
Wonderful. Well, Alexandra, great presentation. Thank you. I'm going to suggest we hold the ESG slides till next time, because I know Smitha prepared some comments and I was going to hand it to her next, if that's okay.
Yes, fine.
Smitha?
Hi everyone, can you hear? I'm sorry. I'm just trying to, I'm keeping my video off for the streaming quality. So the comments I had was not going to be on ESG. Basically, there hasn't been any really major developments in my part of the world, but conceptually there is a new thought that we've been discussing locally, and that is doing away with COMI. So one of the leading insolvency academics in Singapore has made a representation to UNCITRAL that when they're considering the new legislation, to basically consider doing away with COMI and use alternatives instead, because I mean, for various reasons, right? And we've seen this in the Singapore proceedings because Singapore is a financial center. So we rarely have the operations in Singapore. So for us, I mean, we understand forum shopping because, you know, we advocate that as well, since we're never going to have an operational jurisdictional hook to Singapore and we want to be a restructuring center. So anyway, the point of this discussion is that because COMI now has kind of, businesses have moved away from one center of main interest and there's like multiple centers. And when you think of like internet-based businesses, there isn't really a COMI. And so the authors of this idea have suggested alternatives instead, such as...
Hey, Smitha. I
Yes.
apologize for interrupting. It might be helpful just because we have a new bunch of folks on the call. Could you just give a working definition of COMI? Because I think that would be helpful.
Oh, sure. Sorry about that. I'm so sorry.
Yeah.
So generally for cross-border insolvency, COMI is the buzzword. It stands for Center of Main Interest. So if you are a court that is receiving an application from someone who is doing an insolvency process or a restructuring process in a different country. So for example, if there is a liquidation going on in India, and the liquidator realizes there's a bank account in the US belonging to the company with dollars in there, and the liquidator wants to come to the US and get the US court's assistance to get that money out, to take it back to India, you will need the US court to sort of recognize the liquidator. And similarly, if there's a restructuring going on and there's a stay, you'll want to go to another country's court to get recognition of that and ancillary orders to support that. So before a receiving court in another country can consider providing assistance, they need to accept jurisdiction. And they won't do that without looking at this concept of COMI, which is the center of main interest. And the idea behind that concept is really what underpins the model law. And that idea is the person asking the question obviously was appointed in a particular jurisdiction. Did that jurisdiction rightfully basically rightfully open the bankruptcy? So typically, if it's an Indian company and it's the bankruptcy process happening in the Indian courts, then yes, you know, it is very easy to see the jurisdiction there because, you know, it's an Indian company, it's headquartered in India, there's businesses in India, there's employees in India. But increasingly, when you want to establish a center of main interest, companies will have to show the court in a foreign country, hey, court, I need you to pay attention to what I'm asking. And the court's going to be like, you're a foreigner, there's no connection to me. So there's then this idea of COMI, whereby you, the asking party, the asking company, is going to ask the court, hey, no, your jurisdiction is relevant because I have employees here, I have creditors here, I have, I have some contracts that govern under your law. So these kind of connections are usually what people argue and in a way horse trade to establish like, oh, there's a center of main interest or there is some sort of substantial connection. So that's the COMI concept. And that concept is what is the basis of jurisdiction for a foreign court to, in a way, recognize the process and then give assistance. Sorry, does anyone want to improve on my explanation? Because maybe that was a bit too garbled.
I thought that was excellent, and thank you for doing that. I just thought that was helpful, maybe for some folks newer to the concept. And I think you were, with apologies for the interruption, you were starting to tell us about how there might be a departure from that framework.
Yes. So the thinking now, and this has been suggested, and because the suggestion came from Singapore in part, in Singapore, we've been discussing it a lot. And that's the idea of should a court in another country agree to exercise jurisdiction, meaning agree to assist a foreign bankruptcy or foreign restructuring if there's no connection between that court and the company. And this new idea is, yes, it can, because we accept that. Let's move away from finding connections such as center of main interest, and let's acknowledge that there are reasons, good economic and commercial reasons or financial reasons why a particular company may want to restructure in a jurisdiction that is unconnected with its business or its creditors. And this is what we call good forum shopping. So along that vein, what the authors of this idea have proposed is when you enter into your loan agreement or whatever debt obligations you take on as a company, you provide in those contracts that a jurisdiction that you can be permitted to restructure in. So for example, if it's a contract between a bank in Libya, here's a better example, a bank in Australia, and a debtor company in Australia. And in the contract, they basically acknowledge that, if there's going to be a restructuring, it can take place in New York. I mean, New York, we have no connection to the company and the restructuring and the business, but parties have already sort of, at the time of entering into the debt, agreed that if there's going to be restructuring, it will take place there. So the thinking is not so different from the present day dispute resolution clauses, where when you've got international parties entering into a contract, neither side is going to trust the other side's court. So they agree to arbitrate in a third country. And it's a similar kind of idea. If you feel that you like the restructuring laws in a particular jurisdiction, or you feel that this jurisdiction is got other advantages, like for example, it's easy to get DIP financing there, or there's very friendly laws towards releases of guarantees and third-party liability, then you may want to, if you're a company, a debtor, you may want to make sure that you are able to go to those countries to restructure. And you wouldn't under the COMI concept because you've got no connection to those countries. So this new idea is forget about COMI. Let's look at pre-contracting where you can restructure. That's one option. Another option that's been suggested is putting in your contract a third party who will decide where's the most appropriate place to restructure. And the thinking behind this is that when a company starts life, in the sense of when it starts taking on these debt obligations, it may look a certain way. It may have only a business domestically. It may not have, international creditors, or it may have all its creditors concentrated in one country. But, fast forward 10 years later, the company scaled up, it's got businesses everywhere, it's got creditors elsewhere, and you couldn't really predict where the company sort of enterprise is. And so the idea is at the time you want to restructure, you have a third party decide, okay, looking at the whole picture, looking at the creditors, looking at the debt, looking at the type of issues that are likely to arise, this is the country which would be efficient for a restructuring. And so that's one of the ideas. I mean, I can hear some of you on this call already raising eyebrows and rolling your eyes. And that's how some of us reacted. But it's definitely something that's caused a stir.
So I think it's super interesting, and thank you for sharing it. I mean, a couple of questions. Is the idea coming from academics, from judges, from lawyers? Who's putting the idea out there?
So it's academics. So it's a professor from Professor Aurelio Gutierrez Martinez from Singapore, and Professor Tony Casey from the school, Chicago University. So they submitted a joint paper to UNCITRAL, and I think UNCITRAL responded, kind of pushing back, but it's prompted a whole discussion around this.
What would be, my other question is, what would be the limiting principle? I mean, if you do away with a COMI concept, can anybody restructure anywhere?
Yes, that's the idea. Like, it's really like a free market, and their theory is that the market will regulate itself. So basically, they think that this will raise the standards for everyone, because if you want to be a jurisdiction that is considered good for restructuring, you will behave in a certain way. You will make sure that you don't have rogue decisions. You'll make sure that there's principled decisions, that there's fairness, you treat creditors fairly, you treat employees fairly, so that, you know, that's one of the points that was made.
So actually, I mean, obviously Singapore can really only determine what Singapore is going to do and not what other jurisdictions are going to do. But maybe another way to understand the idea is it's really an expansion of jurisdiction. The Singapore courts are basically saying, we will welcome you here, even if you do not have a conventional COMI connection to the jurisdiction.
Yes, and you know, not to be rude about it, but I mean, isn't that what the Americans have been doing all this while? Given the bar for jurisdiction is so low, you can just open a bank account and deposit some money, and hey, you've got jurisdiction, right? I mean,
yeah, I mean, that's fair, and I mean, there's been a lot written about the competition for, you know, for restructuring cases, big restructuring cases, you know, among the U.S. jurisdictions. So, for example, I think I've mentioned in prior meetings, Houston had lost a lot of big cases to New York and Delaware, and Houston found a way to create a small docket with two very good judges, and basically tell the world, hey, file your case here, and you will you'll get one of these two judges, which allowed for a certain amount of predictability and comfort. I mean, the only real difference I see is it may be a low bar to establish venue in a U.S. court, but there is still a bar. And whether it's a bank account or, you know, some kind of contract that's entered into or some kind of affiliate located there, you know, there needs to be in the U.S. still some kind of jurisdictional hook to get you into that court. And I think I mean, it's a provocative idea, but I think what Singapore is saying, or at least what these academics are saying is, well, doors are wide open. We will take anybody's restructuring issue and help them solve it, which is interesting.
Well, it is interesting. And actually, what they were really saying is, look, let's call a spade a spade. Now, in most of the recent big restructurings, people shift COMI. So they're saying, why jump through these hoops? If parties have an idea of where they want to restructure, why don't we just contract for it? Why have this whole farce of shifting COMI, re-domiciling entities, changing the governing law of bond documents just to create jurisdiction? So they think that this is move away from COMI is kind of like no longer fit for purpose in today's business world.
Interesting.
It's really interesting. It's a little bit also the UK is going in this direction with their jurisdictions. They have some decisions which they always said, okay, it's a COMI. They say, okay, it's enough for restructuring in the UK when there is when this is the law of the contract, which has to be restructured as a financing contract. The financing contract is according to English law, then you can do the restructuring in UK. I think it's a little bit in this direction, but not so extreme than you showed it, Smitha.
So what happens? I mean, I understand how Singapore might welcome, you know, a restructuring debtor that likes the legal regime. What if you've got a bondholder or a critical vendor or some, you know, important equity holder who says, I don't want to come to Singapore. I mean, it's a nice place, but I don't want to come to Singapore to restructure my debt. I mean, how do you you can welcome the debtor? How do you get everybody else that's necessary there under this idea?
So the focus, I mean, because this is just like a new idea, so they kind of looked at it from financial institutions, and they basically said the market would price it. So for example, if you're going to choose, if you, the debtor, like jurisdiction X because you feel it's really favorable to debtors, a bank who's going to lend you money or a fund is going to lend you money is going to say, fine, I'm going to charge you much higher interest then because I don't like that jurisdiction. So it becomes like a pricing thing, and then parties settle in something that's palatable to both. based on the economics. So that's how they think it will play out. So same with the bargaining power of bondholders and other parties. The idea is to do it upfront and not when it's time to file. It's meant to be to reduce conflict and reduce litigation around COMI and jurisdiction and get straight to the restructuring. So you save a few weeks and months.
Okay, I see. You basically deal with it as a bargain for choice of law and choice of forum.
Correct. It becomes one of the negotiating things, just like how dispute resolution clauses are negotiated now at the time you enter into the contract. So it'll be another midnight or champagne clause.
Yeah, okay. Sandhya and Supriya, I don't know how much Singapore facing work Vaish does, but do you want to weigh in on this? Do you have any thoughts?
Yeah, one thing I would think is that, see, for example, in Indian insolvency process, there are other people who have a role to play, like apart from the, lenders and the financial institutions, there are the operational creditors. So Smita, if like, for example, parties could choose their jurisdiction at other places, unlike a private lending contract, insolvency affects other operational creditors. So how would you address their interest? Like here in India, we have operational creditors who file in. If they are aggrieved, they can come in and make an application. But suppose the parties were to agree that the jurisdiction is, say, Singapore. Maybe some of the operational creditors may not be able to come to Singapore. They may not be able to afford to come to Singapore. So how does one address that?
Yeah, so where it's not going to be a contract, where the relationship is not a contractual relationship, one of the suggestions by the academics is that you put it in your articles. So basically, it's in your articles of association or your constitutional documents when the company is first incorporated, that should there be a restructuring, it will take place in X jurisdiction, which may not be the jurisdiction of incorporation. So anyone dealing with the company, whether you're an employee who chooses to take up a job there, or you're a trade vendor who supplies the company, you know, because it's been publicly notified to the world or it's publicly accessible to the world, that should things go bad, this company may go to a different jurisdiction. And you price things accordingly. So if you're a supplier and you feel that this company is risky in terms of credit worthiness, you will like have more onerous terms because they might go restructure in a jurisdiction that's out of your reach.
Yeah, if you incorporate in your articles of association, yes, that makes a sense. So everybody is aware of it. That's
correct. That's the thinking. Like I said, these are just ideas. I mean, obviously, there's a big gap between these ivory tower academic ideas and how they're actually implemented on the ground. Like, I mean, for us, I don't think our regulators are very particularly taken by these suggestions, but it's definitely, you know, it comes from the right place, which is that COMI has become very artificially treated these days, and it really is no longer fit for purpose. I think most of us can agree on that. But what should replace it? It's up in the air. No one can really reach a consensus, but at least this conversation has started.
What I find very interesting is, I think you actually used the expression good forum shopping. And I think it's this notion that you embrace the idea of competing for the work. Forum shopping in the US is still a little bit of a pejorative
Negative,
term.
right?
I mean, it's, you know, and we have academics who have said this is bad. It's you know, it undermines the system. You know, if you're a Nevada company, you should be able to go into a Nevada court and restructure, and how terrible it is that, you know, everybody's trying to get to Delaware. Now, obviously, I'm talking about within the US, state to state, but I think the same principle holds, which is, you know, do we want jurisdictions competing for the work? I mean, do we want parties able to essentially opt in or contract in? I mean, I suppose in a way, it's just acknowledging the reality that parties could structure and get the same result. You can incorporate an affiliate in Singapore if you choose. You could buy a small piece of real estate in Singapore if you choose. Everybody could spend a month in Singapore, negotiate an agreement, and have the agreement executed and delivered and located in Singapore. So, I mean, I think it's provocative, but I think it has a lot of logic to it. So I'm I'm certainly intrigued by it, and thank you for sharing it.
No, I will. I'm happy to send you the paper if Hannah, you want to circulate it to the people who joined this call, and so you can just see it for yourself. I mean, it's yeah.
That would be great.
Wonderful.
Smita.
Wonderful. Well, I think we're almost at time. I'll just give a very quick update from the US on an issue that has been, I think, receiving a lot of attention, and I've reported on in earlier meetings, and that is the Purdue Pharma case, and what we call non-debtor releases. In that case, the releases provided to the non-debtor Sackler family members and their affiliates, who were really the owners of the company when it engaged in all the litigation generating activity. And in the years leading up to the Purdue Pharma bankruptcy, the Sacklers transferred, I think, more than $10 billion out of the company. So when the case filed and all these victims of opioid injury brought their claims, there was a pretty serious settlement discussion that took place in terms of how much money the Sacklers would pay back into the bankruptcy case and how much would be available to distribute to the injured parties. And that was memorialized in a Chapter 11 plan. And that Chapter 11 plan contained very broad releases for the Sacklers. And as we've talked about in prior meetings, the statutory and constitutional authority of a bankruptcy court to release claims held by non-debtor parties against non-debtor parties, that authority is very unclear. And what happened in Purdue Pharma was the bankruptcy court approved the releases. The district court, which is the next level of appellate review, reversed the releases, said you can't do that under the bankruptcy code. And that was a very influential and provocative decision. The Second Circuit, our level of appellate review, one level below our Supreme Court, then said, no, the bankruptcy court's right, we can do these releases. And normally in our jurisdiction, the Supreme Court only hears about, less than 100 cases a year. And normally the circuit court is the final rule of law on most issues. But there's been a lot of disagreement and a lot of argument about whether or not these sorts of non-debtor releases are appropriate, authorized, warranted. And our Supreme Court has now taken the case. So the whole question of non-debtor releases under the bankruptcy code is going to be heard and decided by the Supreme Court. And the early thinking is the Supreme Court, as presently constituted, is going to throw out the idea of non-debtor releases, that they are going to be struck down. And if that happens, U.S. restructuring practice will no longer accommodate that vehicle, which is tricky for a number of reasons. The biggest of which is so many of our U.S. restructurings involve equity holders or sponsors putting in really substantial financial contributions and looking to get protection or a cutoff of liability as part of that. So much more to say about that, and I'll report on it in future meetings. But for now, the report here is just that the U.S. Supreme Court has taken the case, and a fairly significant ruling is going to come down in the next, I would say, 8 to 10 months. Hannah, we are at time. Anything else we should cover?
No, I think that's it. I don't want to take up too much time. I will circulate that document when Smitha sends it to me. Thank you all for attending. Just one quick note that I wanted to make. We are hosting WLG at Large again this year, which is our week-long virtual conference for all members, and that will be taking place the first week of December, so kicking off December 4th, and expect an email in your inbox about that the first week of November. But with that, thanks everyone for joining us today. And we'll be in touch.
I just want to thank Alexandra and Smitha for the great presentations. Alexandra, please hold those ESG slides. Let's do them next time. and Julia and Supriya and Valentina and Joel. Nice to see you all, and thanks for joining.
Yeah, thanks everyone.